I'm, my lord, very, very clear about it. And, my lord, therefore, my lord, your
So,
lordship,
Mr. Solicitor, we'll reserve, whether to hear you on the preliminary objection at this stage after they have opened up, just for about 15 to 20
my lord,
minutes. So that we can-
then your lordships may do one thing, my lord. That's the another request. My lord, let them give, my lord, their, my lord, suggest whatever submissions they want, overview, confined to, my lord, what my preliminary objection is. My lord, I can't be
That we will
non-suit.
certainly
Lord,
not. We'll not do
I have to
anything.
open my case.
My lord, I'm sorry, my lord. My lord, I'm sorry.
I'm sorry, Mr. Solicitor. We are in charge. We will hear Mr.
I have
I'm
to
sorry,
open
my lord.
my
Kindly
case.
last minute, my lord, last.
Mr. Solicitor, we'll hear you later.
Yes.
Yes, Mr.
My
Roy.
lord, only a minute, my lord, only a minute.
No.
My lord, your lordships may give me a minute.
Dictate to us how we will conduct the proceedings.
No, I'm not, my lord. I am
I'm not
earnestly
allowed that
requesting.
in my court.
My lord, I am earnestly request. I would never do that. Your lordship knows, my lord.
Yes.
My lord, this is a matter, my lord, too sensitive an issue,
Of
where,
course,
my lord,
yeah.
your lordships would examine the preliminary submissions and, my lord, then give me some time. We may have to consider what would be the stand of the government,
Sir,
my lord, in further participation in this debate.
so trust us to have a broader perspective of everything.
My lord, I fully trust, my lord. There is no question
Therefore,
of
we are
lack
just-
of trust.
We want to understand from them what they want to argue.
My lord, then, my lord, your lordships may give me time, my lord, to consider to what extent the government would like to participate in this.
Anything but adjournment, and I think anything but an adjournment.
No, I understand, my lord, your lordship's anxiety, my lord, I understand. I share that.
So, sir, are you saying that you don't want to participate? No,
But,
very
my lord,
strange
I am
way. This
only
to
saying,
participate, it's a prerogative you have.
my lord, I'll
But
not go
they
that
can
far, my
only-
lord.
No, Mr. This is that. Let me say that. They look nice. When you say that we will see whether we participate or not.
No, my lord, I'll take instructions. I didn't say I'll not participate.
Instructions are here with this constitution.
My lord, the instructions on the question whether which forum should debate and discuss this subject.
It's a very important situation itself. That's the main this thing. Whether the court can go into it or whether only Parliament will legislation issue like this.
My lord, your lordships would examine. My lord, kindly give me 2 more minutes. My lord, this is not an issue which can be debated, my lord, by 5 individuals very learned on that side, 5 individuals on this side, 5 very brilliant minds on the court, no doubt about it. None of us knows what are the views of, my lord, a farmer in South India, a businessman in, my lord, Northeast. My lord, these will have to be, my lord, this will have social and other ramifications. My lord.
Yes, of course. We'll consider that. We'll certainly have that in
My lord,
mind.
your lordships, I'm sure would consider the request. Only request is kindly consider that first.
No, we'll allow them to open the case so that we have
My lord,
an
then your
idea on
lordships
what they
may,
are.
my lord, rule on that.
may I-
That's my prayer, my lord.
May
That's
I
my
submit,
prayer.
my lord?
Yes.
A short preface first.
Statement of state, my lord,
Yes.
on behalf of state of Madhya Pradesh, which your lordship was kind enough to direct it.
Sir,
We
we'll
come-
hear you. There's no
So it's
difference.
not
Your
for
lordship may hear any
intervention, my lord.
state. We have no objection. Your lordship may hear any state.
No, not
Just as a
intervention, I'm
preface,
saying
No, you should have
everything which
joined
the
every state
solicitor
as
has
a.
said does not, my lord, hinge on maintainability of a petition under 32 by an individual who complains that his fundamental rights are being restricted in some form. I have a right to approach this court. This will be a defense, whether your lordship will leave it to the legislative forum or the courts forum. There is no question of saying, my lord, that I should answer that first. I will open my case. They will raise a defense. Please don't touch it. Throw it away. Your lordship do it all the time. Matter of executive policy, we won't touch it. He will say whatever he has to say. But I have a right to file a 32. I have a right to be heard. My grievance may be right, may be wrong. Your lordship will deal with it. And your lordship will deal with their responses about, my lord, this, that, or the other. When it comes, it's not a case of 7-11. That, my lord, a suit is barred by operation of law. That is a preliminary objection. This can't be a preliminary objection that your 32 is there, but the impact of 32 will be this or that.
No, it's
That
maintainability
impact can
is
never be a part
preliminary
of
objection.
a preliminary objection. That be a defense. That don't touch it. This is too overbroad. This, that. They will say all that, my lord. So now, my lord, let me open my case.
Yes.
Well, only one aspect, my lord, and I,
Please now.
Yes.
ultimately
Allow
it's
us
a
to
lordship's
open.
prerogative. But I should not, my lord, be, my lord, told after, my lord, generations after generation, we did not bring this to a lordship's notice. In Special Marriage Act as well as in Hindu Marriage Act, every state have separate rules.
Please.
That makes more, my lord, case for calling all the states and hearing them. Your
My lord,
lordships have, my lord,
My lord,
partial view from both sides.
Only one.
He
My lord,
is very clear about his view. I may be very clear about my view. But none of us represents views of the nation. My lord, that's my preliminary objection.
My lord, the Solicitor General is aware of all the persons that we are talking of fundamental rights. Fundamental rights, by their very nature, are a limitation on the legislative power of the state. Your lordship need not defer to
I'm
Parliament.
not for a second saying
If it is a fundamental right,
is
my
not
lord,
there.
and if it
Who
is,
should protect the fundamental
if it
right?
is a
Whether by
status,
parliamentary law
All right, what
or
we
by
do is,
legislation.
fair enough.
my lord, if it is a status confined to,
We'd like
me
to
open my-
yes, you can tell us.
Yes,
about
let me
15
open my
What
case.
is the canvas of the case?
So, my lord, in a very, very narrow conspectus, my lord, we are persons, my lord, who are of the same sex. We have, my lord, according to us, the same rights under the Constitution as the heterosexual group of the society. Your lordships have held so. I don't need to reinvent the wheel. That we have exactly the same rights as our brethren of the heterosexual group of society, which is the majority. We are a minority. The only stumbling block on our equal rights, equal opportunities, equal dignity, equal fraternity was, my lord, 377. By virtue of 377, our actions were subject to criminality. Because it was criminality, my lord, it could not be equal in all measures of the heterosexual group. Criminality is now gone. The unnatural part or the order of nature under 377 is now effaced from our statute book. And therefore, our rights being equal in all forms, which are, my lord, reflected from Puttu Swami, Navtej, my lord, the judgments of this court on the right to marry a person of your own choice, Shafeen and all that, which I will show. If our rights are identical as held by the state, then we want to enjoy the full panoply of our rights under 14, 15, 19 and 21 to lead a dignified life, not mere existence like your lordship said in Francis Corali Bulletin 40 years ago. To lead a life to our fullest extent with dignity, privacy in our home, and, my lord, without taint or stigma in public places. And therefore, we cherish and desire the same institution between two people as is available to the others, which is, my lord, the concept of marriage, the concept of family, because marriage and family is respected in our society. We don't, my lord, today, my lord, laws have now, my lord, progressed. In the Domestic Violence Act, even live-ins, my lord, are allowed. That is recognized by the court. Your lordship recognize it by even giving, my lord, property, money, inheritance, etc. So there is no reason why, once our rights are identical and same as held by your lordships, my lord. And that has been the development, my lord, in the US and other nations. I have made a one-page chart which I'll show to your lordship. Therefore, my lord, we seek a declaration, because we have to be concrete. What do we want from the court? We seek a declaration that we have a right to, my lord, get married. That right, my lord, will be recognized by the state and would be registrable under the Special Marriage Act and other acts. But as far as I am concerned, my lord, my brief is to say that we want a declaration that we have a right to marriage and that marriage will be recognized by the state by virtue of the imprimatur of this court. And once that happens, the society will recognize us. Because even after 377, my lord, there is a stigma. If two people walk hand in hand in a park, my lord, or in a hotel or in a mall, they are still stigmatized in public. That stigma will only go after the imprimatur of this court that they are entitled to get married, and the state shall recognize it. And once the state recognizes it, it can also be registered. And that will be full and final assimilation of this minuscule group, my lord, into
Now, Mr. Rocky, assuming that you seek a declaration from the court
yes,
that queer people belonging to the queer community,
yes,
same-sex couples,
have a right to
have a right to marry, and therefore the state must recognize the
My
marriage
lord.
between these two. Now, what is the next step? Are you therefore saying that the Special Marriage Act already recognizes that right inherent in it?
Well,
a matter of
Lord,
an interpretative device or an
by an
interpretative
interpretive, Lord, I don't want it to be quashed or anything.
Right.
By an interpretative device, in one line, if I was to say, the provisions, my lord, of the Special Marriage Act made in 1954. Today, my lord, we are now 70 years down. There is a lot of evolution. As I said, my lord, live-ins, etc. have now come in. I want to say, my lord, that your lordships will broadly read spouse in place of man and women or husband and wife. And that is it. And if I may show, my lord, a classic example of the definition of marriage in Black's dictionary, which I will show to your lordship, in 1968, said, my lord, it's a union of a man and woman. But when the definition came in 2019, it says, my lord, a union of two persons. So concept of marriage has changed over last 100, 200 years. We had concepts of, my lord, group marriages. We had very different concepts. We had concepts of child marriage. We had concepts of, my lord, temporary marriages. We had concept that, my lord, prior to the Hindu Code Bill introduced after by Pandit Nehru, my lord, in 1950, a person could marry any number of times. That, my lord, also changed. Hindu Code Bill, my lord, was not accepted. There are a lot of protests to this new avatar of the Hindu Marriage Act. It was not accepted. And Dr. Ambedkar had to resign. Then came the evolution of Hindu Marriage Act. Now in Hindu Marriage Act itself, my lord, in 2005, the rights which were restricted of women, starting from the Women's Right to Inheritance Property Act in 1937, all that has now changed, my lord. And full rights are available in 2005. So, my lord, Constitution is a living document. The preamble says, my lord, equality, fraternity. And I will read passages of, my lord, the Chief Justice, my lord, judgment, my lord, in Navtej, in Puttaswamy, in Shafin, in Deepika, and Justice Kaul, my lord, also referring to it. This is the thread. If this is the thread of the Constitution, equality, fraternity, justice to all, today we are a part of the all. The only thing which was stumbling, my lord, was that criminality. That is now gone. If we are a part of all.
So really, your analysis is two-step. One, the declaration of marriage as a fundamental right
My lord.
as being implicit in the constitutional guarantees
My lord.
14, 19, and 21.
No, as interpreted by lordships, my lord, in Puttaswamy,
Yes, of
Navtej,
course.
basically.
And then step two, the second limb of your submission, that this also can find recognition by a reading,
My
an
lord.
appropriate
My lord.
reading of the
My lord.
Special Marriage Act.
My lord.
So you're not going into the broader issue of personal law and other things, we take it. Right?
No, my lord, I am not.
Right.
And I am not also touching any personal law of Muslims, etc., my lord. Somebody may raise an issue, I am not. Hindu Marriage Act, yes, but basic first will be Special Marriage Act. And your lordship knows, my lord, a legislative tool in the Indian legislative devices has always been that a definition clause always starts with, my lord, your lordships are aware, unless the context otherwise requires. That is the elasticity given to every legislation, more or less, in this country by Parliament, that you have to, my lord, adopt or adapt to 20, 30, 50, 70 years later. Can't keep changing the law, can't keep changing definitions. So you have, unless the context otherwise requires. So if the context requires that a man and a woman or a husband and wife to be treated as persons or spouses, your lordship will do it by an interpretative tool, number one. Number two, this question, that whether, my lord, the court should wait for the legislature to act. Firstly, it arose, my lord, in Navtej. The court, my lord, entertained rather than waiting for the government to, my lord, remove it or not remove it. But there is, my lord, authority for the proposition in, my lord, Navtej, Shaira Banu, Puttaswamy, that the court need not wait for legislative, my lord, interference. And if it is brought to the court's notice that my fundamental right is being restricted, my lord, by the state or by this society because of its mindset, which has to now open up, the court's duty is to act. That is, my lord, clearly laid down. My lord, our lives are passing by. We are getting older. We also want to have the respectability of a marriage, respectability of a couple. What is the point of saying that only criminality in your bedroom is removed? But, my lord, when you go out, there is a passage of Justice Chandrachud, my lord, in one of those judgments, that what matters is what happens in a public space. What is the concrete position? If today, my lord, what is the position? All right, 377 is gone. But if these people, call them queer, call them strange, people call them all different names. If they were to go to different places, people look at them. Look, they are going this way, they are going that way, they are doing this, they are doing that. That, my lord, that is a restriction or an infringement of my right, which is Article 21, to, my lord, live with dignity, freedom, privacy, full expression of thought under 19(1)(a), no discrimination under 14, and, my lord, in 15, as the lordship knows, there will be no discrimination only on the ground of sex, creed, etc. And only on the ground of sex, lordship judgment, Justice Chandrachud, talking about Nargesh Mirza, that Air India case, and, my lord, that Anuj Garg, that, my lord, the Delhi hotels case where, my lord, women could not, my lord, become employees. So your lordships have accepted Anuj Garg, which is an expensive definition of sex to mean sexual orientation. Sex does not mean, my lord, only male, female. And your lordships have, my lord, discounted the verdict in Nargesh, clearly. So Anuj Garg has been accepted by his lordship Justice Chandrachud in that judgment, and also, my lord, in Nalsa, where we're dealing with transgenders, there are passage after passage that if you have to give them equality, that equality, my lord, also must reflect positively. So you have the negative part, don't discriminate. There is a positive part in 14 and 15, affirmative action also. My lord, sorry to say that Nalsa said that give them reservation. Years ago, nothing is done. Years ago. Your lordship judgment, my lord, in Navtej, give full publicity. Today I read in the Indian Express, today, your lordship judgment says give full publicity. People must know that it's not a criminal offense. Don't look at them with this stigma. My lord, years ago that judgment was delivered. Nothing done. And the three ministries today say, we have not done anything and we are not supposed to do anything. If this is the state of affairs of legislative, my lord, interference or legislative response to judgments of this court, I have no choice but to knock at the doors of this court and say, my lord, I have a sense of deja vu. I was here. I opened the case on 377 years ago, before 5 judges, 5 years ago, in this court. This is how, my lord, we reach step 1. And there is a passage in Justice Chandrachud's, my lord, verdict, which I will show, my lord, that this was the first step. That is that sense. This was the first step. Remove that obstacle. Bring them up to the mark with the others. They will walk, my lord, shoulder to shoulder. The Constitution said secular. What is secular? Regardless of caste, creed, color, sexual orientation, full expression. So we are a part of one homogeneous whole, but with the similarities of caste, creed, color, religion. But everybody is entitled in our secular polity, a pluralistic society. Justice Abarwal, my lord, in Coelho, secularism is a part of basic structure. Equality is a part of basic structure. If they are a part of basic structure and a part of the triangle, my lord, I would say quadrangle, not triangle, 14, 15, 19 and 21. If they are a part of that which are inalienable, part of the basic structure, cannot be removed by anybody, cannot be tinkered by anybody, as understood by your lordships. I am not reinventing the wheel. Whatever I am saying, my lord, is actually a paraphrase of what I have read in the last couple of days from those judgments. And I will show you some passages. I am only going to put the pieces together, my lord. And I have, my lord, for a lordship's, my lord, convenience, Justice Bhatt might recall, my lord, in that reservation case, I had made a big chart to show you how the judgments went, my lord, in reservation. Here I have made, my lord, your lordships found it, my lord, useful. Here I have, just hold on, Lord. I have made, my lord, a one-page chart. Starts, my lord, with, my lord, 1860, the penal code. Your lordship just have a quick glance. It will be easy. This will give your lordship, my lord, a very quick glance. Because I think only Justice Bhatt was there, my lord, in that case. The 5 judges here. Kindly, my lord, just see. Input my juniors, and not by me. I only dictated, my lord, the flow. So yes, so today is the rainbow, my lord. This is the rainbow. Kindly see, my lord, Penal Code by Macaulay. In fact, Justice Chandrachud has used, my lord, the full name of Macaulay, which I didn't, which said Babington.
Yes.
Then, my lord, these were laws introduced in different colonies under the British Empire. 47 is our constitution. 67, my lord, was the Sexual Offences Act enacted by Parliament, which legalized homosexuality in 67. Now, see, my lord, September 96, US is very, very, my lord, interesting. US federal government enacted DOMA, which stated that federal law shall not recognize the same-sex marriage. Because, my lord, pausing here for a minute, some states had started recognizing. So center came and said, we will not recognize because they have state and central lordship. So they formed, my lord, this DOMA that we want to keep away. Then, my lord, came Lawrence versus Texas. This was a case where there was a raid, my lord, in the house of Mr. Lawrence. And during the raid, he was found to be, my lord, committing an act which was held to be this unnatural act, and he was then charged. Object was raid, but they found him, my lord, in the bedroom, etc. So, in Lawrence, my lord, the Supreme Court upheld the right of Lawrence. It struck down, my lord, that Texas law, which was, my lord, akin to our 377. Then came Nas. Now see 2013. In Windsor, my lord, the Supreme Court struck down DOMA. That is, that federal law was struck down by the Supreme Court, my lord, by the US Supreme Court. Then came, my lord, Kaushal, which reversed, my lord, the Delhi High Court. Then 2013, the UK Parliament enacted another act to confer equal rights and protect dignity of same sex. 2014 is our NALSA. Now mark 15. In 15, my lord, in Obergefell, it recognized the rights of same sex, legalized the same in the country. My lord, your lordship may mark, and I will show the definition of marriage in this judgment is classic. What is marriage? How, my lord, important it is. I'm going to show that. How important it is. And this happened, my lord, in 2015. And this is referred to, my lord, in Navtej and Shaira Banu both. Then, my lord, came Puttu Swami. I am not reading, my lord. But there are some passages, my lord, of His Lordship Justice Chandrachud, as His Lordship then was. And I have given those passages which I am going to read. And some passages of Justice Sanjay Kaul. Then, my lord, Shafin Jahan and Shakti Vahini. Here also, my lord, if I may say so, the common thread is the Chief Justice. In regard to, my lord, the right to marry a person of your own choice. If you have a right to marry, my lord, a person of your own choice in the heterosexual group, and we are identical to them in terms of our right, it follows, it's QED, it follows that we should also get it. And therefore, you will have to, my lord, qualitatively interpret the laws which were framed in 54 to now fall in sync with what your lordships have said in the last 5 years. That is, my lord, Shafin Jahan. Then came, my lord, Article Section 373 on Johar. Then in 2022, US enacted Respect of Marriage Act for protecting validity of same-sex marriages. Currently, 31 countries recognize the same-sex, but I've given the names. Then came Deepika Singh, Lordship, Lord the Chief Justice. Again, right to marry, familial relationships, or even queer relationships as they are called, is specifically, my lord, dealt with, and that it should be, my lord, can be a family unit, etc. Now, see, my lord, the last definition of marriage in 1968 in blacks. Marriage as distinguished from agreement to marry and from the acts of becoming married is a civil status condition relation of one man and woman united in life, in law for life for the discharge the other and communities of duty legally incumbent or those whose association is founded on definition of sex.
Union relies on. Now it's changed.
Now, my lord, your lordship may mark here, the union relies on the 1968 definition in the counter affidavit. A detailed counter has been filed by the union of 40 pages. So it's not correct to say that I have to now again look at, my lord, what the government will say. They filed a big affidavit, very big affidavit. And they rely, my lord, on the 68 definition. But see, my lord, the definition of 2019, after, my lord, society has evolved. The legal union of a couple. The essentials of valid marriage are parties legally capable of marriage, mutual consent, any actual contract in the form of law. Definition, Lord, of same-sex 2019, ceremonial unit of two people of the same sex, whether man or woman. This is the evolution.
Then is union following this?
So, my lord, union, government of India is following blacks, but it is following an antiquated edition. If you are following the same, my lord, definition or the same dictionary, I say follow the latest version. You can't follow a version, my lord, which is 50 years old. So, the ultimately, my lord, it is this. Not the Chief Justice has put it. I want, my lord, I request, not want, I request. For example, my lord, the two petitioners in the first case, who are they? Two individuals who met, who had a bond of faith, love, partnership. They want to, my lord, reach the status of a married couple, like the other persons, and have a family. They cherish the same, my lord, what is cherished by the others. They want to lead a dignified life, what the others also lead, and not always to be looked upon. Look at them, look at them. For that, your lordships have removed the one block that they can't go to jail. The second step has to be affirmative, which is a recognition of the right to marriage so that we are equal, recognized by the state, so that, my lord, society then follows the state. Because society, my lord, is resistant to change. Human beings are resistant to change. So society follows what the law is, and the law is what is, my lord, said in parliament or what is declared by this court. That is the law.
The only thing which we'll also need to apply mind to, if you
Right.
look at your chart,
My lord.
if you see the US, September 96, the federal government enacts the Defense of Marriage Act,
Yes.
which says that the federal law shall not recognize same-sex marriage. Then comes 2013, of course,
Windsor.
the UK,
Or in UK.
Windsor, that's right.
Yes.
And then 2013 comes the act in the UK, conferring upon all
My
same-sex.
lord, Windsor is also there.
Yes.
Windsor, my lord, 2013.
Yes, that's right. Windsor.
When Doma was struck down, the federal law was struck down.
And struck down Doma.
My lord.
Right. Then comes in the UK, you have a legislation which recognizes same-sex relationship.
My lord.
And then finally in 2022, you have the US Respect for Marriage Act.
Yes.
2022.
Yes.
So you had in the US something which was debilitating, which was removed from the statute book. Then you have something positive which is enacted in the UK, and then which is enacted in the US as well, the 2022 legislation. Now, what we therefore have to really consider is exactly what the other side is
Yes,
urging.
yes, I understand
That
the drift of the question anyway.
these essentially matters where even in the US and the UK, legislature has intervened earlier by outlawing and later on by recognizing. In the absence of legislation, how does the court go about it?
Yes, I understand the question.
Is there a contra? I mean, is there any indication in our legislation precluding the court?
So, my lord, yes.
Or is there a legislative space within which the court can then interpret?
Yeah, I understood the question. My respectful submission, my lord. One, my lord, your lordship may see the judgment is Obergefell in 2015.
What is the right of marriage and what is the constitutionality of an enforcement of right of marriage? Because what they are saying is you live together, you want to do whatever you want, but you can't tell that you want to perform whatever ceremony you want to do or whatever you call it as a marriage, but you can't give an imprimatur and say that that will be registered or recognized. That's, therefore, we'll have to go back to what is the enforceability of a right of marriage.
So, my lord, if I may answer first the Chief Justice. My lord, if your lordship sees 2015, I have understood the drift, my lord, there the legislatures acted. They acted pursuant to the judgments or feelings of people, they acted. Here, but in 2015, my lord, as far as Obergefell is concerned, it recognized the right of the same-sex marriage and legalized the same. That was a judicial imprimatur. It legalized.
Correct me if I'm wrong.
Sorry.
There were constitutions and there were laws which were amended or enacted which prohibited gay or same-sex marriages. Same-sex marriages. Obergefell actually struck down that and said,
Right.
you have a right to marry. Now, the wheel has turned a full circle, where you have a complete federal cover, in the sense that you have a
Yes,
respect,
Your Lordship is right.
right? So we are at that stage.
Yes.
So
Yes,
the
Your
question
Lordship is
being
right.
put is, we are at
Now,
that stage, so how do we go about this?
so, my Lord,
One is the declaration part,
which I am seeking. My Lord, what I am respectfully submitting, answer to both of your lords, so three of your lords. My Lord, if, as distinct from UK and other places, if we have a fundamental right under 14, 19, 21, whatever, to be treated as identical and equal to our other brethren, then the full enjoyment of our rights to be equal to them includes the right of dignified life. If it includes the right of dignified life, which includes the right to choose a partner for marriage or choose a friend or a freedom of expression, whatever we want to express, need not only be in writing, expression can be, my Lord, in love or other forms. And that it is now settled that it is innate, it is not an acquired, my Lord, thing, call it queer, call it what you like. If the rights have to be identical, then I must get the recognition of my union the same way as the recognition of the union of two others. And since it is based on an infraction or an implementation of my fundamental right, I can come to the court and the court need not wait for the legislature. And there is a direct passage, my Lord, in one of these judgments in Shahraman. So, my Lord, I can't keep waiting. There can't be a mandamus to the legislature. Legislature may or may not do. I cannot force the legislature, neither can the court. By that time, our lives will have gone. And our fundamental rights will be in name. That there is a 5 judgments of the Supreme Court saying that you have the same rights, same panoply of rights, passage after passage. If it is the same panoply of rights, there must be a remedy. And the remedy can only be a declaration to that effect by the highest court of the land, saying that this is a fundamental right. And once it is the imprimatur of this court, then, my Lord, it must follow that the state is bound to respect it. Then the society will respect it, and the stigma in the workplace or the public place will then go away, and I'll be able to enjoy, my Lord, a unit of marriage, a unit of family. Because that is what is accepted in our society. So in short, I need not wait for Parliament to do what it wants to do, because there can be no mandamus. And then your lordships have said repeatedly, if fundamental right is involved, the doors of this court are open to an individual. I have a right to come here. I have a right to complain that this is what is happening to me in real life. You know, it is happening to us in real life. When we go out, when we talk, when we meet people. Slowly, my Lord, it is being accepted because the criminality is gone, but not to its full panoply. Because people say, what right have you to get married? Which law? Which court? You got a judgment from the Supreme Court in the first one. Where the second one? So unless and until, my Lord, I get a recognition of law under Article 141, because that the other legislative thing is not available to me. Vishakha or whatever. If I have, my Lord, a right, that right must be examined by the court, and if found, it must be guaranteed. 32 itself is about of fundamental rights. It must be guaranteed by the court. How will the court guarantee it? My Lord, it's not a case of property that your Lordship will take it from him and give it to me. Or some money, my Lord, taken from me and give it to him. Your Lordships will, my Lord, give it by a process which is known to law, which is, my Lord, interpretation of my fundamental rights, and thereafter interpretation of the law concerned. And then leave it to Parliament that this the court has done. If you want to formalize it in law, as Justice Bhatt put it, if you want to formalize it in law, you jolly well amend the act or do bring a new act, as these countries have done. But if you don't, my Lord, the law can't remain static. Law moves, society moves, there's evolution. Rights are different, things are different, thoughts are different. Therefore, the court will act when it is called upon to act. It will do whatever it can within, my Lord, its judicial parameters.
So in other words, like two alternate lines of approach for the court. Assuming you are right that you're entitled to a declaration.
Yes.
I mean, assuming, of course, we have to hear the other side. Assuming you are right that there should be a declaration of the right to marry,
Yeah.
then there are two courses of action according to you. Either the court then finds a legislative void in that Parliament has not legislated
Right,
expressly to recognize the right of marry. And therefore, finding a legislative void, you supplant that
Yes.
deficiency so long as Parliament
My
enacts
lord.
law. The other option is to locate the modalities for implementing that declaration
Yes.
in existing law.
Correct. So, my lord, my short, respectful, most respectful answer would be, if you take Vishakha as an example, in Vishakha, there was no law at all. The court laid down a set of rules which was to work as interim law, if I may use that phrase, interim law or rules and regulations under Article 141 till Milord Parliament acts. Parliament then acted. But the void was filled up in Vishaka in this form. I am saying that in our case, because of our past history, Vishaka had no history. There were no cases before that. We have past history of Puttu Swami, Navtej, all these cases, Shafin, etc., etc. In that past history, all I am requesting is the second step, and the second step to be implemented not by the Vishaka rules, but by virtue of the law already available by a process of legislative interpretation. That's how I would put it.
Vacuum which it filled in and
Yes.
the law which came in. Are you canvassing for filling in a vacuum, leaving it to the legislation to do what it wants?
No, my lord, I am not saying that your lordship may give a declaration, then leave it for somebody else. No.
Therefore, I asked that question.
Yes. Because, my lord, life is passing by us by. We can't wait. How long will we wait?
So you're looking
I-
at an
sorry.
interpretation of the legislation as it stands that should be expansive. This is what
Can't hear you.
So it's from there.
I know. I can't hear that conversation. Can't hear it. What happened?
They are discussing. The bench is discussing.
If I have a constitutional or a fundamental right, and your lordships declare so, and this act remains the same, then there is a conflict between this and the constitutional or a fundamental right so declared. So one way is that this must give way to the constitutional declaration. We don't want it to give way. The simpler way is to read it down, to be in accord with the declaration, my lord, which I am seeking. Yes, because, my lord, legislative drafting of 1954 to, my lord, my constitutional right after 50 or 70 years. This drafting cannot stultify what I am constitutionally entitled to get. If I am right, if I am wrong, it's all over. If I am right to get a declaration of the nature that I am seeking, my lord, in 2023, then there is no way that, my lord, a drafting of a statute in 1954 will, my lord, we will
First part, my lord, there are two thoughts. The
That side is not being shown. The solicitor side.
our model, where your lordship in constitutional adjudication have equalized and brought the left out category into the existing category, my lord. Not just the executive instruction case in Nakara. In All India Sikkim Old Settlers recently, following Vishnudas, Handimal, ITO Lawrence and other cases, where, my lord, some people were left out of certain benefits. Your lordship said striking down will deny everybody the benefit. I will now equalize them, my lord. A good body of case law. The other is the Fowry model, my lord, of South Africa, where they said the common law understanding and the statutory understanding is unconstitutional. We strike it down, but we suspend the declaration. No doubt in South Africa, there's an express provision in 172 permitting that. But, my lord, that was how they equalized it. But your lordships have gone one step further. Read in, my lord. But your lordships have read it in, my lord. Nakara was an executive instruction case, but I've got statutory provisions where your lordships have equalized the left out category. The last of which is, my lord, the judgment 3 months back in All India Sikkim Old Settlers, where the Indian origin settlers who did not give up citizenship, my lord, of India, were left out of the Sikkim register. And our Income Tax Act, my lord, confined benefits to people who are in the Sikkim register. So our argument was, we never gave up the citizenship pre-accession. Lordship said, yes, we will now equalize you.
Different ways where reliefs are molded.
Reliefs are molded.
Prabhakar.
That's the rent control matter.
No. During an interregnum period, the retirement age had been decreased from 58 to 55.
Oh, yes.
This court, by constitution bench, upheld it. But later, due to public pressure, it was restored.
Yes, yes.
In between, people had retired.
Nagaraj.
And what was restored was with retrospective effect.
Yes.
The court said not giving retrospective effect is resulting in discrimination and gave it retrospective. One of those rare instances where relief is molded in a particular manner, where legislation intends a certain consequence.
Consequence, my lord.
So,
Now,
Vishwanathan,
my lord, in
will it
Sikkim,
not involve
the classic case where your lordship equalized it. So, my lord, that need not, my lord, deter or, my lord, should, my lord, hold back the court at all. If your lordships find that confining the status of marriage to heterosexual couples is wrong, and this is, my lord, a status which requires recognition by the state, denied to a set of people who otherwise have fundamental rights. Your lordships find that, your lordships have already, according to me, in Navtej, when your lordship said equal platform, words are, my lord, very specifically used. Your lordships will, my lord, say that they have to be recognized and brought into the sphere. It is for Parliament to tailor law to bring it in accord with fundamental rights, my lord. It can never be that, my lord, you await for them to legislate. That will be, my lord, submitting to, my lord, popular will, which, my lord, is completely contrary, anathema to fundamental rights. The whole idea of fundamental rights is to, my lord, to keep it out of the reign of majority.
Now that we have understood, broadly, we've understood the canvas of the matter, then we can really, at least at this stage, we are not ruling it out for the future, we can steer clear of personal law in that case. So if we steer clear of personal law, then perhaps we make the first, I mean, that is one possible option as you opened it up.
As far as two of us are concerned, we are not leading. There may be other people.
My lord, there are concerns about the Hindu marriage.
Because it may not be necessary for the court then to get into more next issues pertaining to personal law.
It's codified.
Yes, my lords, Hindu marriage, the
It's
Hindu Marriage
codified.
Act,
So perhaps you can all address us on this aspect. That's why when we began, we as
Can I take 2 minutes?
just a minute.
5 minutes.
Just a minute.
The possibility,
The states must be heard. It's a constitutional issue.
Dr. Gurswamy?
My lords, thank you. My lord, the Chief Justice may recognize, my lords, that the Hindu Marriage Act is not an issue necessarily of personal law, it is statutory law. And we will demonstrate that. The terms of the Constitution, the reform of the Hindu Marriage Act has always been in the context of statutory law. So, my lords, to that extent and that extent only, in the context of statutory law and making statutory law workable, because my lords will know, my lords, that the origin of the Hindu Marriage Act, the Hindu Code, did something that was not permitted in sacramental Hindu law, which is intercaste marriage, Sagotra marriage, divorce,
Inheritance to
Maybe Dr.
inheritance.
Guruswamy, but there's also Dr. Guruswamy, there may be some amount of sage wisdom in also going about our interpretative task in incremental manners, because otherwise, do we then confine ourselves only to the Hindu Marriage Act? And what about the Parsi Marriage Act? What about the Muslim law? What about the Jews? What about the Buddhists? A lot of other communities. Therefore, perhaps one option for the court, because the constitution itself and the law is itself evolving. So, and the court has to be mindful of the fact that we are doing by process of interpretation what you're calling upon us to do. So it may be, there may be some element of judicial discretion, and perhaps going incrementally, covering a canvas for the present, which would substantially then, assuming that even there you are right, because you have to hear the other side, confine yourself to this incremental canvas, and then allow society to evolve, allow Parliament's perceptions to evolve over a period of time, because Parliament is also responding to the evolution of society over a period of time.
What is the canvas after Ms. Guruswamy is finished? I want just 3 or 4 minutes. We finished?
Yeah, go ahead.
But it's only 3 or 4 because Lenfred is given, my Lenfred is given.
Because we can't deny the fact.
On canvas.
We can't deny the fact that there is undoubtedly the legislative element also involved, which is why we are states, the parliament, what the
My
solicitor said.
respectful submission.
Having regard to that, we need to balance out various facets. So this might be perhaps one way forward.
That's the only thing I'll say to this. Is
So we don't have to decide everything to decide something in this case.
no, my lords, I follow. I follow. The only thing
There
I'll
are,
say to
Guruswamy,
yes, my lords.
one is the channel pointed out by Mr. Rodgi in a restrictive sense that only construe the Special Marriage Act. If it founds favor with us, it will give us status of marriage. If it not, he rightly said you are out. Therefore, whether other issues at all arise or don't arise, will depend on how we interpret this aspect. Other issues may survive for another day, or may not survive for the time being for another day, depending on what view we take on this core issue. And in the wisdom, as the Chief Justice said, sometimes incremental changes in issues of social and society ramifications are possibly a better course. There is a time for everything. There is time for some things to come. Therefore, what was being suggested was, can we, for the time being, confine it only to this limited issue? Don't step into, let me complete. Don't step into personal law issues under different religious norms. Don't get into any of those issues, but only say that, can the Special Marriage Act be interpreted in a manner by reading into it a general, a gender-neutral situation, period.
Can I say?
And perhaps you can then help us, you can assist us, and we'll ask the solicitor also to assist us on how we can sort of develop the notion of a civil union, which really finds recognition in our statute, namely the Special Marriage Act. See, because now, for instance, I'm sure you wouldn't also deny the fact that between the time that Navtej was delivered and today, our society has found much greater acceptance, say, of same-sex relationships. For the last 5 years that we have seen it unfold,
Definitely.
and that's very positive, because there you find that there is a greater acceptance in our universities. And by the way, our universities don't consist of only urban kids. They all come
Yes.
from the
Yes, of course,
smaller,
all over the country.
smaller areas, yes.
Yes.
But there is this acceptance which is evolving. So, you know, in this evolving consensus, the court is also playing a dialogical role to
Yes.
create that consensus and move towards a more equal future.
My lord,
While being conscious of our own limitations, which
Yes,
we can't
my lord,
deny
I
in
follow.
the legislative arena.
I follow. My lords, the only request I would make is that the question may be left open to be adjudicated.
Obviously, we're not going to reject what we don't.
Yes,
We
madam.
can always confine our
Yes.
canvas and then not reject.
Yes,
Obviously not.
Yes. And my
That is not
second
necessary for the court to do at all.
is simply this, that the second point is simply this, that marriage is not only, as if that were not
But
enough.
leave broader and broader issues for an evolving future.
Yes, but marriage is not only a question of dignity, as if that were not enough. It is also a bouquet of rights that LGBTQ people are being denied post-Johar. Right? Those rights are simple things. Bank account, life insurance, medical insurance. I, for instance, frankly,
Rental accommodation.
I cannot buy SCBA medical insurance.
Citizenship.
I am a member of the SCBA bar. I cannot buy my family medical insurance from the SCBA. So this is the reality of how rights are exercised. Rights are exercised when you are able to protect your relationships. One facet of that right is a constitutional value of dignity, equality, fraternity. The other facet of that rights is the day-to-day business of life. And the day-to-day business of life is all of these things. Now, when we look at law in India, and all common law is premised like this, that most rights flow from this notion of blood relationship, i.e., either being born into the family or being married. That is the problem, my lords. And so, therefore, short of full marriage, whether my lords find that under the Special Marriage Act or be that as it may, short of full marriage, it will mean, if it's short of that, it will mean that subsequently, not just Mr. Rodgi, Mr. Kripal, me, we will keep coming back to court to have to litigate individual issues of discrimination. I am not able to nominate my partner for life insurance. Now, these are not theoretical issues. This is our life. Right? So therefore we say marriage, because that is the notion, not only for society, but that is the notion that the legal framework, which is premised on common law, understand and takes within its fold. So therefore, my lords, respectfully, therefore the problem is that anything short of that, if it is a civil union, so this correspondence will now start, my lord, with insurance company, with banks, with hospitals, with wills, with estate duties, with anything that is prerequisite to being able to live a life outside the home, including buying that home. So the status, and so there are folds here.
Mr. Rodgi, taking a cue from what she says,
Yeah.
see, even in Puttaswamy, when we laid down the right of privacy, we were conscious that it had many nuances. We said we can't beforehand take all nuances into account and rule on this thing. As it evolves, things will evolve. That's the basis of the.
These are absolute day-to-day issues.
So,
Take the Income Tax Act. The two partners can't give a gift. Gift is not free of tax,
Rodgi,
but provided without you are married.
if you succeed, I'm saying if you succeed on the fundamental issue,
Yes,
that it can be read into,
things will work out.
many nuances will start, may take time to work out, it may require more visits to the court, one can't say. But it is very difficult to say that we work out all possible nuances now, even the nuances which you think exist at the moment, to be taken as a bundle of things and dealt with. Therefore, the suggestion which was following was, let us, if we confine it to this fundamental issue under a particular act, that's it.
Yes, well,
We don't touch personal laws, we don't touch anything else. We don't get into anything else.
Whereas on the canvas, I want to say this first.
Yeah.
On the canvas, just 1 second, but on canvas, there are two words here. Of course, on the confinement, it is with great respect, the better profitable way of doing it. There are very valuable arguments by the Hindu Marriage Act batch, or even by other personal laws. Both of us, in the two lead matters, are not arguing that. We are only in SMA. So, Malas, a way to start would be to limit it there. I entirely bow down to what is falling from my lords. But Malas, on the canvas, just 3 or 4 minutes, because there are two crucial words here: marriage and persons. Same sex is a slight misnomer. The correct word is person, not same sex. I'll just take 3 or 4 minutes first. Marriage, largely, my learned friend is covered. Whereas there is two categories of consequences. These are consequential issues she's raising. One is the minor or major secular consequences of marriage. Your lordship is not in this matter. In the event that your lordship holds marriage to be this way or that way, not creating an empty shell called the word marriage. It has to have some consequential benefits. Marriage, well, in any case, now you can have a live-in. You need not even call it marriage. It is because of the consequential benefits. So your lordships may need, this is entirely a lordship discretion. I understand it's a great advance in law if your lordship even were to interpret same person marriage as a marriage. I'm not at all diluting or reducing that. But your lordships, according to me, even in this more limited canvas, must consider traveling a little ahead. One category is what my learned friend has said. These are secular incidents of daily life. They involve nothing beyond that. And your lordships can have a reasonable listing. Now, there are larger issues which your lordship will explicitly keep open. I would say that even those can be covered by marriage, but possibly, Malas, we are too early to start doing that. There is succession law, certain aspects. There is adoption law, certain aspects. There is certain other things. We are not at all, Malas, giving it up or lessening it. But your lordships in this, the crucial word which fell from the Chief Justice is incremental. Malas, I always believe that, Malas, your lordships in such matters is like a rubber band. Malas. Your lordship expands incrementally slightly. You stretch the rubber band too much, your lordship is pushing pressure that the rubber band will break, because that slowly movements is on the societal view of the rubber band. Now, adoption, according to me, is crucial. Is crucial. There may be some non-adoption issues which your lordship may not consider crucial. I'm not able to, in fact, itemize. But your lordship will guard against holding on the left hand, in the event your lordship so holds, that marriage of same persons is valid, and on the right hand, make it an empty shell. That is point one. Point two of the canvas is even more important. The point arises from not having to come to your lordships every day. That's why I said the word is actually more appropriate. I've looked into this, some literature, same person. Now, your lordship has got, one is heterosexual marriage. Lordship will call it this side. One is man-man or woman-woman, which we call homosexual or lesbian, on the other side. Now, there are two actually parameters of differentiation. One is sex-based, which must include between the man and woman sex. There is also a whole range of combination of persons with special biological features. It's not only man, it's not only woman. The second category is gender. That is the masculine, feminine. So a male body can be imbued and overshadowed by completely female psychological instincts, and vice versa. So therefore, once your lordship holds today, assume, as a matter of argument, that your lordship were to hold that same sex marriage is valid. Same sex in the sense of man-man, woman-woman. It is not intended that persons who are in this, what is known as the whole range of shades, the complete spectrum. What your lordship we tend to say LGBTQ. I looked it up. It is L, lesbian, G, gay, B, bisexual, T, transgender, Q, queer, I, intersex. And then your lordship says A, asexual. And then your lordship says plus plus. The actual correct thing is, so this plus plus is a whole shade, a spectrum of different hues and colors. Now, clearly, if your lordship were to hold same person marriage, your lordship doesn't mean to limit it to same sex marriage. In the event your lordship were to hold, so that your lordship doesn't have a tomorrow a new person coming here and saying this. So the correct formulation would be two consenting adults. I'm only giving a summary. Two consenting adults along the bodily, gender and sex spectrum. Either you define by gender or by sex spectrum. This is the other facet. Now, all of this can be profitably started with Bills SMA, because your lordship is making a start. Were your lordship to leave the rest of it explicitly open, or your lordship may have a deferment and have it considered separately, it's entire your lordship discretion. They have also valuable points. I'm not only in the Hindu Marriage Act category, other people also. Hindu Marriage Act category is there also. Secondly, let us be very clear. I heard with some alarm, my learned friend's opening intervention. Nobody is arguing at the moment, nobody, I will not say, at least the two of us, or the three of us, are not arguing personal laws at all.
We are also not. We are also
We are not.
Number three, we are, what is the meaning of this repeated thing about state intervention? Your lordship, for the first batch, is interpreting this way or that way, whether SMA, and our arguments, that is, my arguments are in two parts. One is these fourfold parameters of discrimination, which is the most important, 15, 14. Second is freedom of expression. The very interesting facet of freedom of expression, your lordship has said, is symbolic in a community sense, not only individual. Third is dignity, 21 and other things. Fourth is how to remedy it. And the second part of the submissions is the entire notice objections regime of the SMA. That part would have to be held unconstitutional. The first part is interpretive. If your lordship is with us on that, the second part would have to be unconstitutional.
The
Now,
notice issue is even in a heterosexual marriage, because you are saying that even in a heterosexual marriage, the fact that you have to give a notice and have people object to whether there should be a marriage or not is unconstitutional.
The funny part is, and this is just an aside, that the object, howsoever noble, of having this section 5 to 10 regime is being proved by statistics on the ground to have the exact opposite effect. Exact opposite. Your lordship invites opprobrium, oppression, physicality, violence, elimination, extermination. And I'm asking myself one question. Your lordship has conditions of marriage in all, even Parsis, Christians, Hindu Marriage Act, other acts. Conditions of marriage are there, something or the other is there. If you give an affidavit saying I'm satisfying the conditions, and your lordship subsequently files the affidavit to be false, or any spouse finds it to, even a third party finds it can be struck down. It's void or voidable, it's struck down all the time. You don't need to have a notice period in advance after the conditions. This is peculiar to only the SMA. Your lordship is not allowing those conditions to be violated by the non-following of objections. It's a absurd situation. Now, that being the situation. Yes. Sorry, I can't. This intervention about state objections.
No, I'm saying therefore, you say you don't want to touch personal laws, correct? And we've also put to you don't touch personal law.
I have not touched.
Then the argument is in a very limited compass or
Focused.
Then confined is, can we in the Special Marriage Act read a person instead of the definition of a woman or man?
That's all.
That's all.
And leave everything else for some
Better day.
good time in the future.
That's
My lord, just one aspect.
and no state intervention inhibits your lordship.
May I then proceed?
My lord, just one aspect.
I think then
One
again,
minute.
I think we'll now get back to Mr. Rodgi. So we'll get back to Mr. Rodgi.
My lord,
Now
my lord,
clarified. 1 second, just 1 second, 1 second. We have, I think, all of us on the bench have now clarified the area, or you may call it the limited area, or the area that we are going to explore in this case. Let's hear Mr. Rodgi on that, because I
my
think
lord,
now,
just
on the ambit,
to
my
get
lords.
this.
My lords, briefly,
My
just
lord,
on the ambit, if I may be permitted.
This,
My lords,
which
we have
just
challenged
broke.
in addition the other two secular legislations, and many of us have, which are the Foreign Marriage Act and the Citizenship Act.
my lord, that's
My lords, with regard to the Citizenship Act, the word spouse has been used in 2015, subsequent to all of these other legislations. So if the doctrine of casus omissus is applied, all that is required is very, very low hanging fruit, my lords. All that is required is to be said that spouse means spouse.
See, one thing is either we confine it to this, the debate will be limited and we'll know whether we agree with you or not today. If we don't agree with you, nothing survives.
So,
All those issues, all other issues don't survive.
Lord, sir, when you're,
If we, one
My,
second, sir.
my lords,
Okay, if we, suppose we agree with you on this
Yes, my
limited issue, then in what ramification, what nuance the other thing survives will be a second innings,
my lord,
second, third, what time.
look, the Foreign Marriage Act is actually a secular act, which is really a takeoff from the Special Marriage Act. So that would have to be included in this
You
canvas.
can add supplement.
It is only
Let's do this. Let's do this
one
now.
of the
We'll now start with Mr. Rodgi's submission, so that we can now look at it. We can now look at it with a sense of a constitution bench hearing.
So that it's there. My lords can tell us whether we should then address. My lords, as Dr. Singhvi has already addressed, the petitioners before you are not necessarily same-sex couples. In fact, in my petition, the Rituparna Bora petition, there are petitioners who have anonymized themselves because they are coming from oppressed castes and communities. They are trans persons, irrespective of sexual orientation or gender identity. The relationships are in place. So perhaps same-sex will not include them in that description. I will.
Yeah. Therefore, the emphasis was on personhood.
Person, same
On
person.
person.
Same person.
This aspect, we are also chosen family.
Consenting
Typical family. Can they be, like there is a live-in, can they be a chosen family, particularly when my natal family is hostile? These petitioners have faced hostility and violence from the natal family.
That's the perspective we wish to give.
A chosen family, both to take care of them and the accruing rights.
All right. Now, Mr. Rodgi, you can open now.
can I,
My lord, as far as I am
Mr.
concerned,
Rodgi, now tell us about what's the time estimate for you?
my lord, all my time has been hijacked by people on my side.
No, but now we sort of, now the constitution bench begins as a constitution.
Can I-
Now confine yourself to this.
Only this.
Lord, your lordship.
Yes, only this.
Lord, your lordships, while fixing the remit of the matter also, your lordship said that we would hear the side. Would your lordships like to consider hearing us? Your lordships have fixed the remits.
All right. Yes, certainly, Mr. Yes, Mr. Yes, Mr. Mehta. Certainly. Yes, Solicitor.
Lord, and this is, my lord, I must, my lord, make it, my lord, I in fact achieved an impossible thing today, my lord, making my lord the Chief Justice angry. Few people have done in past, but I am not in very excellent company, my lord, I must confess that. Lord, first of all, the question really, my lord, we are misdirecting the question. The question is not right of equality, right of dignity, or right of privacy of persons who belong to LGBTQ community. That is first. The question is right of conferment of a socio-legal status and whether that can be done by judicial adjudication. But so far as, my lord, kindly give me 15 minutes, my lord, to give the chronological events. Lord, there was no law governing, my lord, the rights and other rights and other, my lord, immunities to the LGBTQ community, my lord. Nalsar judgment came, thereafter Navtej Johar came. Lord, now kindly see, my lord, my affidavit. I am not on the merits of the matter, my lord. On merits, I have different arguments. Please see the Transgender Act. Most of the arguments, my lord, are covered. There is no legal lacuna. There is a statutory framework and there is a conscious omission by the statute. My lord, in my IA, my lord, I have annexed a small act. My lord, this is 2019 Act after Navtej Johar.
I'm not talking about transgenders here. Lord,
Your
my case
lordship
is
have
not on transgenders. My case is not on transgenders.
Lord, my learned friend may allow me now. My lord, I never interrupted him.
But then, sir, I am on my legs. I want to finish my thing.
Lord, he has not seen the act. Otherwise, he would not have said this.
Wait. We have permitted your side to.
I know that.
Just open and
to
give
get
us
a perspective.
No, I am not saying no,
You
Lord.
couldn't plead violation of
No,
article.
I am not complaining. I want to get on with it.
Also get a right to set forth the contour, then we may be able to put some.
I appreciate, no, I'm not.
How while limiting what we propose to limit, so that
Lordship.
then unless you know what he has to say, how can
Lordship,
So
please.
this is, of course, my lord, subject to my first respectful submission about the maintainability. But my lord, just I'm assisting your lordships on this. My lord, this comes after your lordship's judgment of 2017, my lord, the Johar judgment. My lord, please see, my lord, so that my learned friend rest assured. Page 34. Your lordships have that, my lord, my application.
The act actually.
You've got the act. Your lordships have the act, my lord. Kindly see section 2. I'll not read all sections, but some of the sections. Appropriate governments, your lordship can skip. Establishment, defined. Family, defined. Inclusive education, defined. Institution, defined. Please come to 2K. Transgender person means a person whose gender does not match with the gender assigned to that person at birth and includes trans man or trans woman within bracket, whether or not such person has undergone sex reassignment surgery or hormone therapy or laser therapy and such other therapy, bracket over, persons with intersex variations, gender queer, and person having such socio-cultural identities as so and so, so and so, so and so. Correct, my lords? Your lordships concern freedom of choosing sexual orientation. No objection, my lord, cannot have any objection. That's my lord's judgment. Freedom of privacy, no objection, act take care. Discrimination, there cannot be, the act takes care. I'll my lord show to your lordships. The limited question is conferment of a socio-legal status and whether that can be done by judicial adjudication, and I'll come to special marriage act. Lord, now please see prohibition against discrimination. Lord, all arguments that we are not getting this, we are not getting treatment, we are not getting, Lord, please see this. No person or establishment shall discriminate against transgender person on any of the following grounds, namely the denial or discontinuation of unfair treatment in educational establishments and services thereof. And transgender here means LGBTQ plus, not my lord, transgender as we colloquially or my lord, conventionally understand. The unfair treatment in or in relation to employment or occupation, the denial of or termination from employment or occupation, the denial or discontinuation of unfair treatment in healthcare services, the denial or discontinuation of or unfair treatment with regard to access to or provisions of enjoyment or use of any goods, accommodation, service, facility, benefit, privilege, or appropriate or opportunity dedicated to the use of general public or customary available to the public, denial or discontinuation of unfair treatment with regard to right of movement, denial or so and so unfair treatment with regard to right to reside, purchase, rent, or otherwise occupy any property. These are all criminal offenses if there is a denial. Denial of access to removal from unfair treatment in government or private establishment in whose care or custody a transgender person is, then recognition of identity of transgender persons. Recognition of a transgender person shall have a right to be recognized as such in accordance with the provisions of this act. Right to dignity, right to personhood, as my lord, the Chief Justice said. A person recognized as transgender under subsection 1 shall have a right to self-perceived gender identity. Application for certificate of identity. My lord, statutory certification is given that you are falling within the definition of transgender under 2K, based upon which you exercise your rights. And if there is any violation, there are penal provisions. Then issue of certificate, change in gender, my lord, even if, my lord, in LGBTQ, there are changes which take place, my lord, because of hormonal therapy, other therapies, operation, etc. My lord, there is a concept of fluid gender. Sometimes a person is male, for a few days he is female, etc., etc. Let's not go into it. That's on the marriage, and we have much to say on that. Change in gender. After the issue of certificate under subsection 1 of section 6, if a transgender person undergoes surgery to change gender, either as a male or female, such person may make an application, then he gets a new certificate. Obligation of the appropriate government. there are statutory obligations, either central government or the state government, as the case may be, to take steps to secure full and effective participation of transgender persons and their inclusion in the society. The appropriate government shall take such welfare measures as may be prescribed to protect the rights and interests of transgender persons and facilitate their access to welfare schemes framed by that government. Appropriate government shall formulate welfare schemes and programs which are transgender sensitive, non-stigmatizing and non-discriminatory. Appropriate government shall take steps for the rescue, protection and rehabilitation of transgender persons, etc., etc. Then, my lord, obligations of establishments and other persons. Lord, there is a provision for a reservation for transgender persons. It's not, my lord, right now, nobody is arguing the question of dignity, respect, privacy, etc. Right to choose one's sexual orientation. The definition is widely worded. Any deviation from the normal sexual my lord, orientation is protected under 2K. And, my lord, rights are given, and any discrimination is criminally prosecutable. Right now, the limited question is, can by a judicial adjudication process, this honorable court create a institution of marriage for the simple reason, Lord, whether we like it or not, whether they give it up or not, whether, my Lord, your court would go into it or not, it necessarily affects personal laws. Lord, Hindu Marriage Act is a codified personal law. Islam has their own personal law. Part of it is not codified. Hindu law also, part of it is
Getting
not.
into it, Solicitor, we said
Only a
earlier
minute.
to them that so far as personal laws are concerned, we are not at present getting into that arena at all.
That's not the point. Somebody who is Hindu, who is not here, can come and say that, why did you not give me the same treatment? I want to be Hindu. I want to marry under the Hindu Marriage Act. And if you give benefit,
But we are not getting into it.
We are
Why?
not getting into it. So then where is
your
the
lordship will
compulsion?
have to. Right now, your lordship don't have that argument.
We of
There's no
course not.
compulsion. We
No,
must get
Only, like, can
We
I?
don't have to decide the broader in order to decide the much more restricted
what he
arena.
said.
Another aspect, and which I that confining the remits, my lord, I have something to say, my lord. Lord, your lordships would have Hindus, Muslims, everyone, whether your lordships go into or not, everyone will be affected, and therefore the central government very respectfully but specifically, my lord, prays that states will have to be heard.
How many times will you
That's
say
the
the same
question
thing?
we are trying to pose, Solicitor. If we are not touching the person, it's like saying that you must touch personal law. We don't want to touch personal law. We don't want to touch personal law, then why state should be heard? We are confining our remit at the moment only to one issue. So for that issue, whatever has to be heard
No,
is
my
only
lord,
for that issue, which is
marriage.
under the special completed, then you may answer. Under the Special Marriage Act, can we read it in a manner that it is a person? That's all. We are saying we are not going into it. Why should there be a compulsion of the court? You must go into it.
So Solicitor,
That's
can you
it.
give an example of what you're trying to argue? Because if the remit is being defined in this manner, how do you say that this has some other reference?
Yes,
If you are
lord,
that's
one Mr. A, he is Hindu. He wants to continue as a Hindu. He wants to get married under the Hindu Marriage Act. He wants to undergo the.
We're not going to address
We are
that at all.
saying we are not rejecting or accepting. We are saying we are not doing it at the moment.
Lord, we are then begging the question, my lord,
Maybe
to reach somewhere. We are, my lord, short circuiting the issue, my lord. That's kindly, my lord, allow me. Kindly let me. My lord, I am for the first time begging that I may be heard.
to create something which we are not doing, and then you say
I am obliged.
understand what is that you are saying. We are saying we have confined them. They may have opened a very wide chapter. We said no, we don't want to get into that wide area. We don't get say we are only deciding this A issue, we are not touching other issue. Nobody is being prejudiced because we are neither rejecting it nor accepting it. Then we can't be compelled to hear everything else.
No,
at this
nobody
stage.
is compelling, my lord. At least on our side, we are saying your lordship should not hear.
No,
We are not
but
compelling.
you are saying don't hear this alone. Hear everything or hear.
No, I'm saying don't hear it, my lord. I'm
You are
not.
saying don't hear it at
I'm
all.
saying let the parliament hear it, my lord.
That's right. But therefore, we are trying to steer a middle course, which is that we don't want to
Lord,
first say that, well, we will decide
Lord,
everything.
when we are deciding fate of,
And then be confronted with this argument.
it has several windows have opened.
The window, you'll have to open the entire door. So don't do it.
I would, my lord, kindly on the lighter side and don't take otherwise. Several windows have already opened. Now they are trying to open the door, and I am saying that you will have to ultimately open your entire house.
Mr.
As an
Solicitor,
example, the question is whether those
He is relying on those windows which have opened.
windows have got sufficient breeze inside or not is the question.
Now,
And-
another aspect.
and those windows are willy-nilly going to open whatever we decide, because society is not dependent on.
Lord, I
on
must, my lord,
legal
say as a
arguments.
citizen.
Windows have opened up.
No, I'm no, my lord. I'm saying as a citizen. I'm not saying yes or no. Societal relations, acceptance of any relationship in the society is never dependent either on legislation or on judgments. It comes only from within. Let us accept it, whether we like to accept it or not. But leave it at that. That's, my lord, more on my lord, other philosophical aspects. Your lordships are persuaded to take up Special Marriage Act, possibly, my lord, on the ground that in one of the section the word used is spouse. My lord, my respectful submission is this, and kindly, a person, my lord, not a spouse. My lord, my respectful submission is this, and kindly, my lord, examine this correctly, a little, my lord, closely. Even Special Marriage Act, and I will show, my lord, if I have to, my lord, at the subsequent stage. The legislative intent of the legislature throughout has been a relationship between a biological male and a biological female, including Special Marriage Act.
But Mr. Solicitor,
Number one.
there is a very important value judgment which you are making, that the very notion of a biological man is absolute, or that a notion of a biological woman is also an absolute notion,
Never change.
which is incorrect.
The only
No.
biological man means biological man. It's not a question of notion.
Possibilities of rights.
Yes, of course it is.
None of us.
There is no absolute concept of a man or an absolute concept of a woman at all. That's the
Lord,
whole
I am-
argument in a broader constitution.
Biological man, my lord, means man only. It means, my lord, biological man. It's
Biological
not a
man is
matter
not a
of
definition
notion.
of what your genitals are. It's far more complex. That's the point.
We stop having rights if we are not a biological.
So even when the Special Marriage Act says man and woman, the very notion of a man and a notion of a woman is not an absolute, based on what genitals you have.
Lord, biological man means genitals you have. Lord, I didn't want to use that expression.
That's a point of view.
Lord, another thing, for man, irrespective of other attributes than the genitals, there are separate age limits prescribed. Lord, what are we doing? That's not an argument. That's not an argument.
Or we said it is not a mandatory thing that the whole society must accept something. Changes have always come in.
But your lordships will have to examine whether marriage is a fundamental right. Right to marry, divorce the law is a fundamental right.
That's what I want to establish, no?
Lord, only a minute.
What
Only a
else do you
minute.
want to
Lord,
establish?
only a minute.
Seeking to confine.
Lord, I know my difficulties. Lord. I know my difficulties, but I am still discharging my duty. Lord, there are several acts. If the notion is treated to be a guiding factor to decide man or a woman, then I will show several acts which your lordships would unintentionally make non-workable. I may have, my lord, genital of a man, but if I am otherwise a female, my lord, as my lord possibly trying to be suggested, then, my lord, how would I be treated under the Criminal Procedure Code? As a woman, my lord, can I be called? For 160 statement after a particular hour, I may say that this is only a notion. I may have a biological genitals of a man, but now I am a woman. My lord, there are several issues, my lord, which have to be gone into, better they go into, be gone into by the parliament. And your lordships, my lord, kindly appreciate. But the parliament, we have good, eminent parliamentarians on both sides. And I can say this based only on my reading. My lord, parliamentary committees are not, my lord, acting the way in which, my lord, we see parliaments functioning. Parliament committees have all parties as members.
The lighter side, they say that real work is done in the parliamentary subcommittee.
Yes, yes. My lord, they call witnesses, they call expert witnesses,
Mr. Solicitor,
they
you're
call
right.
stakeholders,
Mr.
they
Solicitor, you're
decide.
right. We have, both Justice Kaul and I, we have engaged with the department-related parliamentary committee. I chair the E-committee, Justice Kaul chairs NALSA. We have engaged extensively with the parliamentary committee. In fact, part of the reason why we have this huge support now for the E-committee is because of the
I know, I'm
bipartisan
aware of.
support
In
which
a
the
different
parliamentary committee
capacity,
gave
I'm
our
aware.
work.
Right. But see,
So, my lord, it's not that, my lord, there are certain issues, my lord, which are better left to the discretion
we
of the
got.
parliament. Your lordship's, my lord, concern, the government shares. No discrimination, no breach of privacy, right of choosing one sexual, my lord, orientation, everything is taken
But
care of.
Mr. Solicitor, you are underestimating the impact which your argument is having on us. Don't underestimate the impact which your submissions are having on us. And now it's our turn now to put those problems to Mr. Rohit when he addresses.
Another aspect, my lord, another aspect.
We know where we are trying to find. We are also
I'm
trying to
fully
see where we can
confident,
draw the
my lord, I'm
lines.
fully confident. I'm fully confident. Only a minute more. Only a minute more.
You may continue. I'm only saying they came with a broader canvas, much broader canvas. We are saying we are unwilling to go into the broader canvas. We are not willing to go into the broader cost. We are not willing to go into personal laws issues. We are not willing to go into ABCD. Therefore, they have agreed to, for the time being, confine it only to the aspect which we are willing to rule on. And it cannot be said we must rule on everything. We are only willing to rule on that aspect. If that is the only remit which we are willing to consider, then naturally their arguments or your arguments, you may have arguments whether it can be done under this act or not, whether even what is being sought to be canvassed by them should be left to the legislature to consider whether they would like to get into it. But the remit or the contours of the argument will thus have to be restricted only to the extent we are willing to consider the issue. It can't go beyond.
I'll just
That's all
give
I'm
an
saying.
example why I'm saying this. I'm just giving an
And
example.
it is
Live
still open to you to argue in response that don't go into even this limited remit. That is again a
I'm
issue
obliged.
which
I'm
we
obliged.
are more
Lord,
than
what
open
has
to
happened
hearing.
is,
There's no
what has
difficulty about
happened is this. In Navtej Johar, when the limited question was decriminalization of Lord, section 3, X mentioned in 377, the central government very carefully filed an affidavit that we leave it to the wisdom of the court. We are not, but there we did say in no uncertain terms and recorded by your lordships that this is not an issue where we were even remotely touching about other issues of marriage, etc., etc. But as my lords have said, the window of marriage did open there. Now, today your lordships may not go into the question of personal laws, but the window of that personal law will open. Lord, ultimately, your lordships are dealing with us.
Solicitor, we cannot ever bind future generations after we are gone.
Exactly
and
my
the
submission
deeds
is.
are dusted and done.
Lord, that's my.
That's the task for the future generations.
Lord, that's from.
Whether
That's
it's
my.
the legislature or the court, I mean, we leave it open to
Lord, that's
future
my.
generations to run
I'm
the
saying.
country with the
No,
sense of
I'm not
maturity.
saying your lordship would bind. Your lordship would never bind. That's the majesty of the court. But your lordship's not going it right now and giving some lord, considering giving some relief, would not mean that your lordships have never gone. That would, my lord, open another. That's all okay, my lord. That's okay. But ultimately, my lord, your lordship will have to consider that this even special marriage act does not prohibit, and entry 5 concurrent list is agnostic. It's not on personal law. It's a law of marriage. It's not Hindu marriage, Parsi marriage, or Muslim marriage. It's a law of marriage. It's their right to legalize, not to legalize, provide for many things, etc., etc. And therefore, my lord, again I am reiterating that my preliminary application, and there is a reason why I am repeatedly reiterating, my preliminary objection be taken up first, and your lordships may issue notice, my lord, to all the states. I am reiterating that request with a purpose, my lord, with an intention.
All right, we'll reflect on it at lunch and we'll take a call. Certainly we'll, now that you
First, may I have 2 minutes, first?
Yes, Mr.
To
Dedi.
add, Manoj. Adopting everything which my learned solicitor says, Manoj. About the canvas, Manoj. So far as the Special Marriage Act is concerned, even if not this court, I'm assuming Manoj, the lordships are inclined to update it or read in something in this act, Manoj, so as to accommodate Manoj, the interests of the petitioner. Even then, Manoj, the first of all, the preliminary issue would be whether, my lords, the heterosexual unions with whom they are seeking equality. Mr. Rotagi himself said that if your lordship holds that they are equal, then the issue of reading in, etc., arises, my lords. Without first going into that question of equality, because it is going to be our strong submission, my lord, that there is no equality, my lords. It is one thing that they claim civil rights of different kind, with all sorts of consequences. Many countries, my lord, have had separate, my lord, enactments giving them certain recognition, certain rights. Even in UK, my lord, first there was a law enacted which gave them separately a right, and subsequently, my lord, this equality was granted by legislation. And therefore, my lords, the first and foremost question is, would this court be holding, Lord, because earlier in Navtej, your lordships never granted absolute equality, Lord, with heterosexual union. That was not the issue at all. So the no lordships have not educated us that no judgment should be read, will not dehorse the issues which had arisen in that case. In that case, not the only issue was about the decriminalization, section 377, which in that context, your lordship made certain observations. Yes, as lawyers, Lord, we are entitled to rely on those observations and try to build further, my lords. But then that is not a final authority, my lord, for complete equality between the two kind of relations. One relation which has been existing, my lord, since time immemorial. Enormous continuity for heterosexual union. And that heterosexual union, my lord, as the lordship knows, is responsible for the perpetuation, the very existence of the human race, its perpetuation. Without it, my lord, the society itself will not live. The nations will not be there. But the other relationship, merely because there is love, affection, and concern and care, etc., that's just one part of the heterosexual union. That's not the core of the relationship. The very heterosexual union, this marriage amongst them, this institution is not the gift of law. It has been existing since Rig Vedas, and it's continued. The Manusmriti continued, my lords. And all religions, my lord, so basically, my lord, these marriages have evolved over thousands of years, my lords, and are based on usage, custom, religion, etc. And the core purpose was to perpetuate the human race. Without it, this relationship, my lord, it can't exist. You may have n number of other kind of relationship. Malanifrin refers to group marriages, polyamorous marriages, and so many things are existing, and this same-sex is not a new phenomenon. It had been existing earlier, and they never claimed equality. They were never given equality. That's a very important aspect. Go as far back as in history, my lord, they have existed, but not on an equal level. Today, under the Constitution, it is one thing that they want to claim. The question is, therefore, what I'm trying to say is that this fundamental question, are they absolutely equal? Once your lordship comes to that conclusion that they are, then and then alone the question will be, do we read it in this act itself without any necessity of declaring any enactment ultra vires and so on, lords? And the second aspect is, lords, that even under the Special Marriage Act, there are two aspects. If your lordship looks at one section, 19. On 19, section 19,
Yes.
The two relations, the two unions are different, at different pedestal. Section 19, the professes the Hindu.
Where are you reading, Mr.? 19.
I'm sorry, miss. Section 19.
Go ahead.
The marriage solemnized under this act of any member of an undivided family who professes the Hindu, Buddhist, Sikh, or Jain religions shall be deemed to effect his severance from such family. So there is a consequence on the personal law. Well, that of course will be, they can say that it's my choice, I'm willing to.
Right, exactly.
That's fine.
This 21.
But then this,
21A follows. 21A follows. Not just 19, 21A. Amended in. PC.
now further, Lord, degree of prohibited relationship. These are all, my Lord, reflections of the personal law.
Yes.
What I wish to say, my Lord, is that marriage amongst heterosexuals or the heterosexual union is not a gift of any of these laws. These laws are only regulating the long-standing relationship which has been existing in our society. They are only regulatory. Now kindly have section 4.
Subsection 6. It talks of biological man and biological woman. 4C.
Now, kindly have 4B first. Neither party, and in fact in A, the expression spouse itself is indicative of an heterosexual relation. That's, of course, a question of submission on merit. B, neither party is incapable of giving a valid consent to it in consequence of unsoundness of mind, though capable of giving a valid consent has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and the procreation of children.
It talks of
So the procreation of children and the perpetuation of the society, my Lord, and the race and the nation is an intrinsic idea, my Lord, spelled out in this. Therefore, that question will have to be decided first. And even if you decide it is equal, whether your Lordship can still, my Lord, read in, change all these provisions so as to accommodate, would be a submission on merit that is not possible even on merits, even if your Lordship holds that they are equal. And then see, the male has completed the age of 21 years and the female the age of 18 years. Now, how can, my Lord, the question of man and women doesn't arise?
It has to be biological man and biological.
Yes.
Now, kindly have section 12.
So these
These are all arguments on merit.
It's on the merits, but I'm just briefly, not cursorily taking your Lordship's.
No, this is an argument saying that don't do this, as the solicitor said, because it has various other ramifications. Even under the Special Marriage Act, don't do it.
With respect, I'm saying I appreciate the fault from my Lord, no, but I'm saying something else. I'm saying first, because of the historical submission which I made, because of these provisions, etc., and because of the fact that under this act, my Lord, the states are empowered to make rules. Therefore, my Lord, the states are absolutely essential party, necessary party, my Lord, and no adjudication should be done without, my Lord, issuing notices and pleading the states.
All right, we'll consider
Particularly, we have moved an application and I have not got an opportunity, so I must be, my application should be allowed, my Lord, and given an opportunity. Thousands
Yes,
of
Mr.
people.
Bill.
2 minutes, only 2 minutes. Well, it's, at least some of us on this side, at least for speaking for myself, believe in the autonomy of the individual. And I think people are entitled to have a relationship of whatever kind, whether it's the same sex or not, Mullis. I think that needs to be celebrated because that's the way society is moving forward. But having said that, Mullis, assuming your lordships were to say it is a valid marriage, it's fair, Mullis, your lordships can say that. Now, Mullis, supposing the marriage breaks down, they've adopted a child, what's going to happen? Who's going to be the father? Who's going to be the tenant? Under procedural criminal law, who is the woman? Who will pay maintenance? These are very, very serious societal consequences of that declaration. Either you take it as a whole or don't take it at all. I'm not averse to either. But if you do it piecemeal, it'll create more problems for that unity, for that union, for those two people, whether they're women or they are. In other legislations, when this has been done, if you look at the legislations around the world, they actually reform all the other laws in tandem with it. If you do it piecemeal, you will actually be hurting that very community. And that's very dangerous. I am all for it personally, but I'm not in this fashion.
So are you saying do everything?
Either you do everything or you do nothing. But if you do it piecemeal, you're going to hurt that union.
You are representing which state? Sorry.
Well, I'm not representing anybody. In fact, I need not even argue because your lordships are leaving out personal law for Jamaat. So I need not even argue. But I'm just,
No, I just want to know.
an officer of the
just to
court.
appreciate the submission, I wanted to know which is the group you represent. If you're not representing Jamaat.
I'm sorry?
Which is the group you represent? Which is the
The
stakeholder?
Jamaat, Malaj. Jamaat ulama. They're not parties. Therefore, Malaj, I am out of it, really, because your lordships have clarified it. I don't have to be here. But Malaj, I want to, no, just as having practiced here for so many years, I need to.
As an officer of the
Yes,
court
yes.
system.
Yes, Malaj, these are very,
Wanted to be-
very complex, serious issues. If you decide it piecemeal, it's going to have huge ramifications. There'll be ghettoization. Imagine the impact in a village.
Mr. Sibbal, what we can do is that
Yes.
at the latter part of the arguments, we'd like you to assist the court for about half an hour or so. Please do.
Deeply obliged.
We come back.
To just take
May I have your lordship
response to what biological
There are certain other organizations.
For
example.
Look, we can't be hearing everybody to open their cases. What we do is now we've got a broad understanding of where the rival viewpoints are. We'll come back after lunch and now begin with Mr. Rohatgi's
Very well.
submission. I
That's
think.
May I have your
The only thing what we
attention?
wanted to say is, not on the merits, but Lord, Bharatiya Sant Samiti, the Hindu chain. I'm not on that, I'm in the
So,
institution of marriage,
now just one
the
thing
society.
on the logistics, Mr. Rohatgi.
Lord, I will finish by 4.
By 4 o'clock.
Yes.
Now, once you have covered this ground,
Yes.
I take it that the others will only make short supplementing submissions.
Yes.
Who will be leading? Dr. Singhvi, how long?
Dr. Singhvi, Mr. Kirpal wants to say.
Mr.
Dr.
Kirpal.
Singhvi, then Mr. Vishwanathan.
So, my lord, I'll just submit.
It was a small.
Just give us a list of the order, set out the order so that we can call out the names
Certainly.
one after the other. And we will take
What
it
we would
that
propose,
maybe all of you should be able to conclude by Thursday.
Very well, my
So
lord.
that we'll give you until the end of
Yes,
Thursday
Lord, I
for
think
the
that-
entire this
that
side.
would be
Fair
sufficient.
enough. And the following week, we can, Malaj.
Even that I feel, once you have addressed.
May
others will have
your
very short
lordship,
submissions.
Supplementing. I don't
Yes.
know if you finish today, how much supplementary can there be?
Not much.
Lord, I will place the relevant judgments which will establish according to me that we have a fundamental right, my lord, to a marriage.
So
and to
perhaps
be
Thursday afternoon, the others
Yes.
can start. I think Thursday afternoon, the rest of us can start.
And I'll get my choice.
Highly
again,
obliged.
Malaj.
But I would.
may I have a turn for a
Lord,
few
your
minutes
lordships
after?
are rejecting my application.
Mr. Solicitor, Mr. Attorney General?
Yeah, after lunch, may I have a few minutes of
Yes,
your lordship's
after
time?
lunch.
Very.
We're highly obliged.